Yes, sir.
Namaskar to all my learner brothers and sisters. I welcome you all to the second online study circle organized by Adhivakta Parishad Dwarka Court Unit on the topic Women's Right in Property. On behalf of Adhivakta Parishad Dwarka Court Unit, I also welcome today's speaker, Senior Advocate Shri Sanjay Podarji. Sir, we have expressed our deepest gratitude for sparing time from your busy schedule to this study circle. Namaskar, sir. I would like to brief you all about Sir. Sir did his schooling from Udia Medium Government School. Sir came to Delhi in 1985 to obtain his LLB degree and completed his law from Faculty of Law, Delhi University in 1988. Sir became Standing Counsel in Land and Equation Department in 2004. Sir was designated as a Senior Advocate of Delhi High Court on 5th August 2011. In today's study circle, women's right is ancestral property will be explained in view of recent landmark judgment of Supreme Court by Speaker Senior Advocate Sri Sanjay Podarji. Over to you, sir.
Namaste. Today I am invited to place my opinion or my views on the judgment rendered by the Supreme Court on 11th August 2020 in the case of Vinita Sharma versus Rakesh Sharma. I will confine my argument, discussion on the impact of the judgment in the existing dispute between brothers and sisters regarding the partition of the ancestral property. No doubt it is a landmark judgment, very important judgment rendered by the Supreme Court, 3 judges bench, which clarify many aspects of the case, the dispute between the parties, which are pending pursuant to the amendment of the Hindu Succession Act 1956 in the year 2005. The main dispute, the main bone of contention was before the Supreme Court as to whether the father is required to be alive. Father holding the co-passionary property is required to be alive in the year 2005 so that the daughter can seek a partition of the property. Or one more question was was raised before the Supreme Court as to whether a daughter can seek partition of a property which already stand partition prior to 2005. Basically, these two were the questions, and these questions rose because of the two conflicting decisions of the Supreme Court. One was rendered in the case of Prakash versus Fulvati, and another was rendered in the case of Damma in 2018, and the conflict was whether the daughter can seek partition of the property, ancestral property, if the father is not alive at the time of amendment, that is in 2005. Prakash's judgment says that in order to seek partition by the daughter, the father and daughter must be alive at the time of 2005, in 2005. Whereas the Nammas case, though partially accept the ratio of the caste judgment, but observe that partition, in order to seek partition, it is not necessary that the father should be alive. Now, the Supreme Court, in its judgment, has examined the provisions of Mitaksha law vis-a-vis co-partnership property. History was stressed out. It's a lengthy judgment of 122 pages. If I have to summarize the same, it can be summarized in few sentences also, but the clarity will not come. For better clarity, it is necessary to understand why the Supreme Court has laid down the law and why this interpretation was given. The Supreme Court in its judgment has said basically that in 2005 the amendment was brought with a view to place the daughters at par with son. Earlier there was discrimination between the two. Daughters, though, may be entitled to a share in the partition, but they did not have right to seek partition because they were not treated as co-partner. Only sons were treated as co-partner and they were entitled to seek partition. If we talk about co-partnery means jointness in possession and jointness in ownership and right to seek partition or right to seek separate possession is one of the incidents of co-partnery right. Since the daughters were not treated as co-partner, they were not given the right to seek partition. In order to remove this discrimination, 2005 Act was brought. And in 2005, the daughters amended Section 6. Section 6 of the Hindu Succession Act was replaced by a new provision. And it says basically that the daughters will get the same right which a son would get in the case of partition in a co-partnership property as a co-partner. So who is co-partner? What is co-partnership property mean? And what are the rights of the co-partner are required to be seen before we proceed further. Supreme Court in its judgment has noticed that in Mitaksha law, which is mainly applicable to northern India, and except Bengal and Assam, there are two types of co-partnership interest, that is unobstructed heritage and obstructed heritage. As I said earlier, co-partnership comprises of in co-partnership it is unity of ownership and unity of possession and right to seek partition. So before 1956, when the act was enacted, Only, only male descendants were eligible to become co-partner besides widow and unmarried daughter who were not, though not co-partner, but they had some interest in the property, like right to seek maintenance and right of marriage. In 56, the changes took place, and the 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 right of survivors, the right of succession instead of right of survivorship was introduced. What is right of survivorship? Right of survivorship is prevalent in Hindu law. Here, if a person has three sons, he himself, the father, and three sons would become co-partner, and they get their share, their right by birth. The moment a son is born or conceived, he gets a right equal to that of other co-partner in the co-partnership property. And this inclusion goes up to 3 degrees. That is father, son, grandson, and great grandson. Beyond that, they are not. Beyond that, the even if male descendants are not considered as co-partner. In the case of co-partner, since they have the right by birth, they have right to seek partition also. So they get their right unobstructed just because of their, by virtue of their birth, and not by virtue of any death in the family. Though before 56, the share used to get, share of each co-partners were fluctuating depending upon the birth and death in the family, death of the co-partners in the family. But if a person who is, say, for example, 4th degree from the common ancestor, he will not get the interest in the property even by birth, unless and until one of the person in between is expired. He will get only upon the happening of death of one of the ancestor. So there is obstruction in his inheritance. Thus it is called obstructed heritage. So in the case of unobstructed heritage, the only criteria is the person gets the right by birth. Whereas in the case of unobstructed heritage, the person co-partner gets the right by birth. Whereas in the case of obstructed heritage, the inheritance gets open only upon the death of the ancestor, not otherwise. Now, since the daughters are co-partners, they have been put at par at co-partners, their right is also unobstructed. They get share in the property as co-partner, as is being given to the son, as unobstructed heritage. If it is unobstructed heritage, then their right is created, right is crystallized by birth, by virtue of birth, not by virtue of death of the ancestor. Unlike in the case of obstructed heritage, where the inheritance is dependent on death. So first principle which was cleared by the Supreme Court in this judgment is that the daughters are co-partner by a deeming provision under Section 6 of the Act. Since they are co-partners, they get their right by virtue of death. So, conclusion, sequitur of this conclusion of the Supreme Court is that the daughter will get the share in the property by virtue of the death, irrespective of the fact whether the birth has taken place before 2005 or thereafter. She will get a share in the property as co-partner. I have been asked one question. A question was posed to me, which I tried to find out from the judgment itself, that if the daughter is born before 1956, whether she will get a share. In my opinion, and as per my reading and understanding, she will get the share in the property, irrespective of the fact whether she was born before 1956, after 1956, before 2005, or after 2005. It is immaterial. Date of her birth is immaterial, because by a legal friction she has been considered and has been given a co-partnership right that equal to her brother. So she will get the same share which her brother would get in case of partition. So time is immaterial. One can argue that the Hindu Succession Act is not creating co-partnership. It doesn't affect the co-partnership if before 1956, if the daughter was not co-partner, how can she be given a co-partnership right in 2005 amendment? But the Supreme Court has interpreted the same as the provisions of the Amendment Act has been treated as retroactive effect. Retroactive effect, the court has considered three aspects: prospective effect, retrospective effect, and retroactive aspect. It is not prospective because the provisions are like that. It will not apply only to the future, but it will apply to the past also. It is not retrospective because it is not trying to do away or done away or remove everything which has taken in the past. The transactions which have taken in the past are protected under Section 6, subsection 5 of the Act. So it is not retrospective. It is retroactive because it is a beneficial legislation which has been enacted to give benefit to the daughters who were being deprived of their parental property. The court also noticed the fact that a daughter is always a daughter. She will always remain a daughter, whereas the son is son till he gets his wife. So this aspect has been taken into consideration by the court and the basis of the judgment. The Supreme Court has further said that death of the father, since it is unobstructed heritage, death of the ancestor is immaterial, even if the father has expired before 2005, for that matter, in the year 1988 or 1995 or 1997, it is immaterial, or thereafter it is immaterial. And to that extent, Prakash judgment has been overruled by the Supreme Court. Not the reasoning was not accepted by the court. I highlight that since 1948, this anomaly in division of property was sought to be removed. The first Hindu code was introduced in the year 1948, giving equal right and doing away with the survivorship concept of Mitaksha law. But due to resistance, it could not be enacted. A middle path was worked out in 1956, which resulted in passing of the Hindu Succession Act 1956. It is a middle path wherein the right of survivorship was protected to some extent, but daughters were also given some right. Female members were also given some right. I would say that the discrimination has been removed to a large extent, but there is still some discrimination. In the case of male co-partner, it goes up to 3 degree, but in the case of daughters, it goes only up to daughter and not beyond daughters to other degree. So this discrimination is still there. I hope and expect in the coming time this discrimination will also be addressed by the parliament. Another is why another issue arose because of this, that the act is retroactive, meaning thereby past transactions have been protected. If partition has already taken place before 2005, those will not be disturbed. So, another question arises from this. What is the meaning of partition having been affected? The court says that partition means partition by metes and bounds, not by imagination or notional partition as we used to use earlier. That has been diluted. Partition means actual partition by metes and bounds, and this was necessary because when the act was amended, giving the same status to the daughter as co-partner, in 2005, it was thought that people will try to create false partition, saying that in 2005 there was no co-partnership property, hence no partition can be sought. So it was felt necessary to define or to crystallize, to put these words in clarity. So the legislature has said partition means partition by registered document or by court of decree of the court. The Supreme Court also took into consideration the earlier practice which was prevalent before 2005, that the partition can also be effected orally between the members of the family. In oral partition, there is no written document. And earlier, memorandum of family settlement or oral partition recording the fact of partition used to be prepared, which was not required to be registered under the Registration Act. But the difficulty arose in this also. In this also, how to prove, how to accept that the partition has already taken place. The court says oral partition, if you plead oral partition which has taken place prior to 2005, then in that case, onus is heavy on you. It will not be accepted merely on a statement. It has to be proved beyond reasonable doubt, in the sense that it has been not only partition has taken place, but it is bona fide and has been acted upon by the by the co-partners in the sense that they have separated. There is severance of status of as co-partners, and the co-partnership has come to an end, meaning thereby you must have applied to the government agency. There must be this fact of partition should be supported by contemporaneous action and contemporaneous document evidence in the public record. Public record is change in the electricity meter, change in my view, change in the electricity meter, water bills, payment of property tax separately after the partition, individually, and mutation in the government record, or in certain cases it has been seen that the daughters have given no objection, and on the basis of that the mutation has taken place, then this no objection from the daughters are part of, if part of the public record, that can be placed into service to prove the fact of dissolution or extinction of proportionary property. Some questions were put to me by the listeners, so I was reading that. Now, the court also considered the fact, has examined those cases where, suppose, the suit was filed in the year 2002 and the amendment came into 2005, and a preliminary decree was passed in favor of the daughter as per the law prevailing pre 2005. What will be the effect? The court says that preliminary decree is not similar to partition of the property. Partition would take place only when a final decree is passed by the court and not before that. And the court where the matter is pending, even if final decree has not been passed, the final decree will be passed as per the amended act, not as per the law prevailing before amendment or at the time of filing of the suit. The court also said that such a plea can be taken in the appellate court where the appeal is pending, because appeal is continuation of the original suit. Now, how it has impacted, this judgment has impacted in the defining the share or distribution of the share. Let us take few examples. Suppose a person father F is father and he has two sons and one daughter, and he has one ancestral house where they are living. Now, if rights are required to be seen vis-a-vis 2005 amendment, before 2005, if partition has to take place, then the father and two sons will only get their share, 1/3 each. The daughter will not get a share in this first notional partition. Then she will get the share from her father's share, that is 1/3, because two brother along with her brother, that is 1/3 for herself and 1/3 for each of the brother. So they will get 1/3 each from father's 1/3 share. So she will get 1/3 of 1/3. Now after this judgment, she will get one third share in the property along with her brother, not one third of her father's share. This is the change which will take place after this. Now take makes slight changes in this. Suppose the father died in 2010, that is after the amendment, and they own the same house is the same, parties are same, they will get equal share in the property, one third each. Suppose the father died in 1980 and 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 she got married and shifted to her marital house in 1999. And if partition is sought now, she will get one third each, even if the father died in 1980. If we consider, if but for this judgment, she would not have got a share in the property because the father died before the amendment came into force. Now take an example how the court, an argument was raised before the court that if daughters are placed at par with brothers, that is son, then it will create confusion and the share will get altered. The Supreme Court has said that in co-partnership, fluctuation of share is inbuilt, it is inherent, it, it is always keeps on changing, but in certain circumstances, it would not get changed. Say, for example, a father has two sons. I would name them father, grandfather, father, and Tauji. Father, grandfather had two sons, father and Tauji. Tauji has had one daughter, and father had two sons. Now, Tauji died before 2005. Then, in notional partition, the Tauji's daughter will get one third share. Her share is defined now. Suppose after that, another son is born to Dadaji, grandfather. Then their share, the father's share, and Dadaji's share, and grandson and uncle's share will change because of the birth. Whereas Tauji's daughter will remain unaltered because her rights are crystallized because of the death. This is how this changes. This will bring a change in the calculation of shares, determination of shares. So this judgment would apply even to the pending cases. In the pending cases where the final decree has not yet been passed, or if the appeal is still pending, though final decree has been passed. The court has summarized the same in the last paragraph, which for the benefit of the listener, I will like to read out. The provisions contained in the substituted section 6, that is amended section 6 of the Hindu Succession Act 1956 confers status of co-partner on the daughter born before or after amendment in the same manner as son with the same right and liabilities. Here one more important aspect is she will get both share asset and liability in the father's property. The right can be claimed by the daughter born earlier with effect from 9/9/2005 with saving as provided in section 6(1) as to the disposition or alienation pertaining or testamentary partition or testamentary deposition which had taken place before 20th day of December 2004. So it is retroactive. It will not reopen the transaction which has already taken place before 2004 when the bill was introduced in the Rajya Sabha for the first time. Since the right in co-partnership is by birth, because it is unobstructed heritage, it is not necessary that father co-partner should be living as on 9/9/2005. So father's death of father is irrelevant. The statutory friction of partition created by proviso to Section 6 of the Hindu Succession Act 1956 as originally enacted, that is 1956, did not bring about the actual partition or disruption of the co-partnership. The friction was only for the purpose of ascertaining share of deceased co-partner when he was survived by a female heir or class 1 as specified in the schedule to the Act of 1956 or male relative of such female. The provision of the substituted section 6 are required to be given full effect, notwithstanding that a preliminary decree has been passed and the daughters are to be given share in co-partnership equal to that of a son pending proceedings for final or in appeal. दैट्स वाई आई सेड पाउजी वाला जो एग्जांपल मैंने दिया था जिसमें उनकी डॉटर का राइट क्रिस्टलाइज हो गया है, दैट विल रिमेन, it will remain unaltered, that court will presume a notional partition only for the purpose of determination of share, not for the purpose of extinction of co-partnership property. Property will still remain co-partnership and will be subject to partition on the claim of a daughter. So only for the purpose of ascertaining the share, defining the share, a notional partition will be given effect to. But for other purposes, it has no meaning. In view, next 5. In view of the rigors of provisions of explanation to section 6(5) of the Act of 1956, a plea of oral partition cannot be accepted as the statutory recognized mode of partition affected by a deed of partition duly registered under the provisions of the Registration Act 1908 or affected by a decree of court. However, in exceptional cases where the plea of oral partition is supported by public document and partition is finally convinced in the same manner as if it had been affected by a decree of a court, it may be accepted. A plea of partition based on oral evidence alone cannot be accepted and to be rejected outrightly. अब क्वेश्चन आता है कि सपोज it is a beneficial enactment. Suppose a partition case was filed before 2005 and by the daughter and claiming the share as per pre-2005 provisions, and it attained finality and the property was sold and she was given her share as per the pre-2005 enactment provisions. Then can she ask for reopening of the case? Since it is not retrospective, she cannot ask for the reopening of the case because it is already completed. So This is the difference between retrospective operation and retroactive operation. If the case is filed, though filed before 2005, but is still pending in the court of law, then the new law will apply. What is required to be proved by her is that the property is an ancestral property. Both and she born, father is no more, and she is alive in 2005. If she is alive in 2005, then she will get the share in the property, and partitions would be decreed in her favor. Few more illustrations can be added to this. Let me first highlight the main points. Right. In para 119, the court has clearly said if the daughter is alive on the date of commencement of the Amendment Act, she becomes a co-partner with effect from the date of amendment, irrespective of the date of birth, earlier in point of time. So, in my mind, there is no confusion as to whether the provision of the Amendment Act would apply to a case where the daughter was born before 1956. The, the other side can also make an argument, but that will be decided subsequently by the Supreme Court. But it is not covered under the present judgment, which clearly, according to me, says that the act would apply because it is for the benefit of the daughters, and legal friction has been created which should have been given full meaning. A question has been asked to me which says if daughters get property through partition, whether her son or daughter can seek partition during her lifetime in view of section 14. The answer is no. As per section 14, any property inherited after partition is her own property. Now let us make few changes in the illustration. Permit me to read my notes on this. A situation is where the father F died in 1990. Her brother S1 and S2 continue to occupy the house in the previous example. She got married and moved in with her husband in 2001. She needs, I think I have already discussed this issue. She filed a suit and got her share as per pre-2005. Before 2005, then she cannot ask for reopening of the case. But if the preliminary decree is passed or the suit is still pending and no final decree has been passed, then she will get her share equal to that of her brothers. So this is the main impact of this judgment. It gives daughters who were being deprived earlier a right in the property, father's property, equal to that of her brother. This is the impact of the court judgment. Vinita ji, Anu ji,
जी सर।
इस पर अभी जो क्वेश्चंस मुझे लाइव मिले हैं, एक क्वेश्चन मैं नोट कर पाया था, तो मैंने उसका लाइव जवाब दिया है। एक क्वेश्चन, दोनों क्वेश्चन जो है उसका दो क्वेश्चंस आए हैं, दोनों का सेम आंसर है मेरे हिसाब से। पहला क्वेश्चन है, विल सेक्शन 6
6 proviso. Will section 6 proviso hold fulfill if capitalism rights have been given to a daughter?
will section 6 proviso holds the field if compulsory rights have been given to
Given to a
daughter?
daughter.
I couldn't get the answer. मैंने ये क्वेश्चन में समझा नहीं क्या है, क्वेश्चन क्या है ये? प्रोवाइजो तो है ना, compulsory proviso to section 6. Let us read which proviso the 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 listener has posed. There is proviso to section 6(5). Huh? नथिंग से शुरू होगा, नथिंग कंटेंट इन दिस सेक्शन शैल अप्लाई टू ए पार्टीशन। ये तो मैंने ऑलरेडी बता चुका, अगर पार्टीशन ऑलरेडी हो चुका है एंड इफ इट इज प्रॉपर्ली डॉक्यूमेंटेड एंड एक्टेड अपन, क्योंकि ये रेट्रो एक्टिव है इसलिए वो रीओपन नहीं होगा। तो पर्सनली राइट, अगर जो 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 ट्रांजेक्शन कंप्लीट हो चुका है बिफोर 2005, एक्ट अपन हो चुका है, पब्लिक डॉक्यूमेंट है, रजिस्टर्ड है, एक्ट ऑफ कोर्ट है, डिक्री ऑफ द कोर्ट है, दोज विल नॉट बी रीओपन, ओनली दोज आर पेंडिंग नाउ or would be filed in future. In those cases this right will be available. मैंने कहा, अभी एक एग्जांपल दिया है कि सपोज 2005 से पहले ही डिक्री फाइनल हो चुकी, उन्होंने अपना पैसा प्री 2005 के हिसाब से ले भी लिया, then now she cannot ask for more in view of this judgment.
Okay, sir. You have sufficiently answered everyone's question, sir. Thank you so much. Thank you so much, sir, for your valuable time. Thank you so much. Now I invite Advocate Vinita Bakshi to deliver vote of thanks.
Thank you, Anu, for inviting me. Namaskar and good evening to all. On behalf of Adhivakta Parishad, I would firstly like to thank Senior Advocate SANJAY sir, our speaker, who embraced our knowledge on women's right in property. Sir, we thank you for devoting our precious time in covering all the important aspects. It was an honor to have you here. Secondly, I am also thankful to Jivesh Tiwari sir, the General Secretary, Delhi Prant, and Jitesh Srivastava sir, President, Delhi Prant. I would like to thank Advocate Akash Vajpayee and Jitendra Kumar for providing us technical support in organizing the seminar. I am thankful to Ajay Pandey sir, our President of Dwarka Unit, and Sandeep sir, Secretary, Unit of all members Dwarka Unit, Adhivakta Parishad. Also, I would like to present a special thank to all my viewers and advocate for attending and make this session successful. Thank you.